I'm Anthony Padgett, and in June 2005 I made a proposal to put on a contemporary art performance at Tate Modern about the importance of religion for art. I proposed to do the performance around a reconstruction of Sir Henry Tate's memorial made out of sugar cubes. This was before Rachel Whiteread made her sugar cube work. The performance was to look at how Sir Henry Tate's religion, Unitarianism, was now shaping the way we look at the world. Tate said my proposal didn't fit in with their programme, so I began my claim of religious discrimination against Sir Nicholas Serota and Tate Galleries in September 2005. I want this case stopped, and I don't want my name involved.
Today's pre-hearing review is not to determine discrimination issues, but to determine jurisdiction. We have to establish whether Mr. Padgett made an application for work within the Employment Equality, Religion or Belief Regulations 2003. As if he did not, then his case is not covered by tribunal. Before giving evidence, Mr. Padgett, you're required to take an oath. Which holy book, if any, would you like to use? The Bible? Quran? Bhagavad Gita?
I'd like to use them all, please, as accords with my religion.
We cannot do that, Mr. Padgett. You can make a Quaker affirmation if you like.
No, I'd like to use them all, please.
Right, Mr. Padgett. As you refuse to cooperate, then I will use the chairman's right to get evidence from you by request.
I don't refuse to cooperate. I just want to swear an oath according to my religion.
First, we must deal with who is the correct respondent. You listed Sir Nicholas Serota, but really it should be the trustees of the Tate Gallery. Are you willing to amend it?
Sir Nicholas Serota forms the policies of the gallery and decides whether religion should be included, so he's a key figure in the discrimination case. Mr. Padgett is a second-rate artist who is cynically out to exploit as much publicity from this case as possible. He is even so ridiculous as to say this case is a work of art and to ask for shortlisting for the Turner Prize as compensation. This hearing is not about the quality of my work, but about jurisdiction. My case is to establish the right of artists all over the world not to be discriminated against on the grounds of religion, race, disability, sex or age when they apply to perform in galleries. No Turner Prize artist has ever considered religion as a theme. Tate's own website even has an article admitting the Turner Prize is racially and sexually biased, but they still do nothing about it. My request for shortlisting reflects the importance of my artwork and of this case. This case is the piece of artwork that I seek shortlisting for.
Are you filming right now, Mr. Padgett?
No. Mr. Padgett didn't make a full proposal. He merely sent ideas for a proposal, and Tate can take any artist's idea and get another artist to make it. No, my proposal was a proposal because it was rejected as a proposal by Tate, who said that it did not fit in.
As we have run out of time, the tribunal will meet alone at a later date to determine the outcome of this case. Well done, Anthony. Tate hired an expensive barrister, but it's obvious to anyone that you made an application.
Yes, now we can get on with the real issue of the art world being institutionally discriminatory against religion.
Mr. Padgett, we rule that your claim fails on 4 grounds. Firstly, you did not say that you would personally put on the performance. Secondly, your submission was not a full proposal. Thirdly, you are not an artist of international standing, so were not entitled to put in a proposal. Fourthly, Tate did not put out an invitation to tender. It was merely an encouragement.
In response to your ruling, firstly, it is ridiculous to say that an artist who applies to put on a performance would not be the artist that makes the performance. Secondly, my proposal was a proposal because it was rejected as a proposal in letters from the Tate. Thirdly, the tender document doesn't require artists to have international standing, which I do have anyway. Fourthly, Encouragement to murder and encouragement to terrorism are legally punishable offences, so encouragement to tender should be covered by employment legislation.
The 4 points are legal points and a matter for Employment Appeal Tribunal.
So I researched the law and sent a 60-page letter to Employment Appeal Tribunal detailing legal flaws in the main hearing. I received a one-sentence rejection in reply. Undeterred, I sent a request for full written reasons and an oral hearing. Mysteriously, this request was lost in the post. The registrar at Employment Appeal Tribunal had discretion to allow this lost request in the interests of justice.
Your request has not been allowed on the grounds that the procedures you were sent say that you should expect a response to request in 5 days, so you should have known something was wrong.
I request a review of this decision as the registrar is in error. There is nothing in the practice direction sent to me about timescales for a response.
The review you requested will be listed for a hearing, but this will be your final hearing.